Hello, everyone. My name is Greg Baylor, and I serve as Senior Counsel and Director of the Center for Religious Schools at Alliance Defending Freedom. As you probably know, in December of 2022, President Joe Biden signed into law the misnamed Respect for Marriage Act, which, among other things, repealed the Federal Defense of Marriage Act and enshrined same-sex marriage into federal law. The new law expands not only what marriage means legally, but also who can be sued for disagreeing with its new definition. This could open the door to litigation against those who disagree with the new definition based on the sincerely held and respectable belief that marriage should only be between one man and one woman. Many of you reached out to us with questions about the new law and how it could affect your religious freedom. We want to help you better understand the implications of this law, so here are some of the answers to some of the most frequently asked questions we received. I know some Christians disagreed about the ramifications of the Respect for Marriage Act. Why did Alliance Defending Freedom take the position it did? Is the law as bad as you say it is? So Alliance Defending Freedom and many of its allies opposed the proposed Respect for Marriage Act for a variety of reasons. First of all, the bill is entirely unnecessary. Those who support it claim that it's necessary to enact this law in order to protect the alleged right to same-sex marriage, which the Supreme Court created in the Obergefell case in 2015. They claim that what the Supreme Court said in the Dobbs decision, which overturned Roe v. Wade, somehow jeopardizes this alleged right to same-sex marriage, and they've expressed the fear, an unfounded one in our judgment, that the court is poised to do this and that they need to have statutory protection for same-sex marriage to back up the alleged constitutional right to same-sex marriage. Well, I think anyone can tell you that the chance that the Supreme Court is going to overturn Obergefell is slim to none. So the bill's not necessary. In addition to that, the bill will have adverse consequences, particularly for religious liberty. First of all, the bill creates an obligation, imposes a new obligation on both governments and organizations working closely with government to recognize, to acknowledge, to support same-sex marriage. And there's a lot of religious organizations, of course, that cannot do that. And again, we're talking about the ones that work closely with government. In addition, there's an enforcement mechanism. If you don't comply with this obligation to recognize same-sex marriage, either the federal government or an activist organization can sue you and potentially get you held liable in a court. Third, the bill could undermine and make worse how courts analyze religious freedom cases. And finally, the Respect for Marriage Act gives the Internal Revenue Service an additional tool, additional ammunition in order to take on the tax-exempt status, potentially strip the tax-exempt status away from nonprofit organizations, including religious ones, that aren't on board with the new definition of marriage. What do you expect will be the immediate effects of RFMA on different types of ministries, including churches, camps, foster care and adoption agencies, rescue missions, and schools? Ministries that are most likely to be acting in concert with the government are most at risk. Entities that are working closely together to pursue some shared goal are the ones that are most likely to be deemed, quote, acting under color of state law, which is the language of the statute. What this means is that organizations like foster and adoption care and placement agencies are the ones that are most likely to be sued under the new Respect for Marriage Act. Again, that's because they're the kinds of nonprofit organizations that more often are working closely with government, and that's kind of the test for who can be sued under this statute. I think religious schools, houses of worship, mosques, synagogues, churches are far less likely to be challenged under the Respect for Marriage Act for not recognizing same-sex marriage. So I think the concerns that those organizations ought to have are actually pretty minimal. What governing documents should a church have in place to provide the most robust religious freedom protections? Does a CMA member need any new governing documents in light of the RFMA? I don't believe that the RFMA requires ministries to create any new governing documents, But at the same time, they should have the sorts of documents that ADF has been advising our Church and Ministry Alliance friends to have in order to protect their religious liberty. They ought to clearly state their religious views on controversial issues and then root them in scripture or other theological statements. I'm thinking about things like standards for employment, employee handbooks, job applications, and policies governing facilities use. All of these should be up to date and to clearly articulate how the ministry relies upon these standards to live out its views about controversial issues like marriage and the distinction between the sexes. Will the Respect for Marriage Act limit my ability as a pastor to talk to my congregation about marriage only being between a man and a woman? Pastors will continue to have the freedom to be able to talk about marriage as an institution that consists of one man and one woman. Now, why is that? Well, there's nothing in the RFMA that challenges the ability to dissent from the emerging orthodoxy about same-sex marriage if they're not working closely with the government. The statute imposes this obligation to recognize same-sex marriage on those entities that are, quote, acting under color of state law. The other way of saying this is, are they a state actor? And it's extraordinarily rare to non-existent for a church, a mosque, a synagogue, any house of worship to be deemed to be a state actor under the law. In addition, the RFMA poses an obligation on folks to recognize same-sex marriage. And that doesn't mean that it forces them to speak out in favor of same-sex marriage. So speaking is not really the kind of thing that will be punished under the Respect for Marriage Act. Could the Respect for Marriage Act negatively affect a church or ministry's ability to make its own employment decisions, such as whom to fire or hire? The RFMA doesn't have a direct impact on the freedom of churches and other houses of worship and other kinds of ministries to hire and fire according to their religious beliefs, including religious beliefs about marriage and sexual morality. Now, that said, we've expressed many times in connection with this bill the concern that the IRS will use this bill as ammunition, right, to decide that those nonprofits that adhere to traditional understandings of same-sex marriage ought to lose their tax-exempt status. And the question there is, what is likely to provoke the IRS to even consider that sort of action? Well, it could be decisions about employment. So I'm not suggesting that any ministry do anything particularly different in the hiring and firing field in light of the Respect for Marriage Act, but I do think it's appropriate for ministries to be aware that hiring decisions might be the thing that provokes the IRS to act on this issue. Will my church be forced to host marriage ceremonies for same-sex couples? Almost certainly not. Recall that the Respect for Marriage Act, yes, it imposes an obligation on many to recognize, to acknowledge same-sex marriage, but it doesn't impose that obligation on everyone. It only imposes it on those who are, quote, acting under color of state law. And in almost every circumstance imaginable, a house of worship or religious school is not a state actor. They're not working closely enough with the government in order to be deemed subject to this obligation. The mere receipt of funds from the government doesn't transform a private organization into a so-called state actor. In addition to that, the fact of the matter is that the First Amendment, the Free Speech Clause, the Free Exercise Clause, the Establishment Clause, clearly protect houses of worship from being forced to perform same-sex wedding ceremonies. And even if that weren't adequate, which it is, there is a provision actually in the Respect for Marriage Act that says the government can't force a house of worship or a religious school to solemnize or to perform a same-sex wedding ceremony. Will the Respect for Marriage Act affect how a church or ministry can use its facilities? The answer to this question is almost certainly not as well, and it's a similar rationale to the answer to the last question. Again, the Respect for Marriage Act imposes an obligation on governments and those working closely with government. When it comes to facilities use, it's hard to imagine circumstances in which houses of worship are going to be deemed to be the government, to be acting closely enough with government such that this obligation under the RFMA somehow restricts their behavior. And again, both the First Amendment and a provision of the RFMA have explicit protection from being forced to recognize, solemnize, perform a same-sex wedding ceremony. Could this new law remove my church's 501c3 status? So the Respect for Marriage Act doesn't directly require the Internal Revenue Service to take away the tax-exempt status of nonprofits that embrace biblical views on marriage. At the same time, it still does pose a threat. The IRS, when it's deciding whether a particular nonprofit is eligible for tax-exempt status, it will ask whether the organization is, quote, charitable. Well, how do they decide whether an organization is charitable? One of the questions they ask is whether the organization, the entity, is acting consistently with, quote, public policy, a very broad phrase open to interpretation. And what we're concerned about is that the IRS will point to the RFMA as national public, established public policy that same-sex marriage is a good thing and ought to be recognized, and those that don't recognize and support it are somehow failing to satisfy the standard of acting consistently with national public policy. So again, the RFMA is not going to directly require the IRS to take away tax-exempt status, but it could use the RMFMA as ammunition in the case that it might build against nonprofits who hold to biblical views on marriage. Now that the RFMA is law, is there anything that can be done to regain lost liberties? Well, in theory, Congress could repeal the Respect for Marriage Act and, restore the freedoms that are at least threatened by the statute. Unfortunately, that seems unlikely. What Congress could do to protect against the potential threats of the Respect for Marriage Act is to enact a statute, or a bill rather, that's been introduced in past Congresses called the First Amendment Defense Act. The First Amendment Defense Act actually protects organizations, individuals, from being punished by the government because of their views on same-sex marriage. We're hopeful that Congress may someday enact that statute. We don't expect it to happen in the current Congress, but it's certainly worth something advocating for in the meantime, so that when the opportunity is available to pass this statute, it can be seized on. In conclusion, while there's some uncertainty regarding the total impact of the Respect for Marriage Act, one thing is certain: ADF stands ready to defend your ministry's religious freedom if it is challenged under this law. We're remaining vigilant, and we'll keep you updated on what you need to know as the consequences of this law begin to take shape. Thank you for reaching out to us with your questions. It's an honor to work alongside ministries like yours that are committed to the gospel and helping keep the doors open for its spread. May God continue to bless you and the work of your hands.